insurance, or recently divorced. Regardless of the reason you may be experiencing financial difficulties, bankruptcy may be an option worth considering. I would like to invite you to go to shouldifileforbankruptcy.com and take our 15-question test to see if bankruptcy may be right for your situation. That's shouldifileforbankruptcy.com and take our test to see if bankruptcy may be worth exploring further. Also, I'd like to point out that we've been designated by Congress as a debt relief agency. We help people file for bankruptcy under the Bankruptcy Code. No attorney-client relationship is established by watching this video, and you should always seek legal guidance for your specific legal situation to see how the law may or may not affect your situation. Don't rely on generalizations found on the internet. Go to a counselor, seek their advice, and let them help you in your specific situation. Now, prior to filing a bankruptcy, you have to take credit counseling. And these counseling classes have been approved for each district across the nation for each state. And you should contact your local bankruptcy attorney to find an approved class for the district that you reside in. And they normally have a couple that they know of. These classes can be taken online, over the phone, or in person, and they'll be able to help you find one that's right for you. Now, the purpose of this video is to give a general overview of a Chapter 7 bankruptcy. Not going to go into great detail. There's many things that happen in a bankruptcy, and I'm just going to hit the highlights that generally happen in most bankruptcies. Again, these things are complex, and you should seek guidance for your situation and what is right for you based on how the law may affect your situation. So seek counsel. All right, when a Chapter 7 bankruptcy is filed, an automatic stay goes into effect, and that prevents your creditors from calling you, suing you, doing anything to try to collect on the debt. And in most cases, that remains in effect throughout the whole bankruptcy, and then the discharge is a permanent injunction against the creditors from ever trying to collect on the debt. Some debts like student loans, some taxes, child support, alimony, criminal fines, other government-backed debts are non-dischargeable and are generally owed after the bankruptcy. Also, any debts that you agree to reaffirm and be responsible for survive the discharge and you would still owe. People sign what's called a reaffirmation agreement, generally on property like property they owe on, like houses and cars that they want to keep and continue paying on. By signing a reaffirmation agreement, you put a creditor back in the position they were prior to filing bankruptcy. So if you later default on that loan, they can come sue you, repossess, foreclose on the property, and you end up owing the creditors money and you've filed bankruptcy. You're able to sign a reaffirmation agreement as long as it's not going to create a financial hardship on you or your dependents. It's presumed a financial hardship if you're spending out more than you're receiving each month. And in those cases, you'd have to go in front of the judge, and the judge would make a determination on whether it's in your best financial interest to reaffirm that debt and whether you can afford it. All right. Also, when you file bankruptcy, the trustee steps into your shoes and takes over ownership of all your property except for the exempt property. And I'm not going to go into all the exemptions for Florida. There's a lot of them. They vary from state to state. There's a federal exemption rules, and states can opt out of the federal exemptions and create their own. I will tell you, Florida has opted out and created their own. And again, you should seek guidance from a local bankruptcy attorney to tell you how the law is going to apply in your specific situation. But I will say, generally, most people are able to keep all their property and don't have to pay anything to the bankruptcy court, but cases do vary and you should seek guidance for your specific situation. Generally about a month and a half after the bankruptcy has been filed, there'll be a creditors meeting. At that creditors meeting, you'll be sworn in by the bankruptcy trustee and ask questions about the paperwork that's been filed in your case. This creditors meeting is just that, to get you under oath, swearing that everything's truthful and accurate. And the trustee will ask you questions like, did you list all your property, all your creditors? Did you review the paperwork before it was filed? Those sorts of things. Also, your creditors can come to the meeting and ask you questions. Generally, they don't. Normally, it's just a few-minute hearing, and after the hearing, it's pretty much over with except for the waiting. I mentioned that you had to take credit counseling prior to filing a bankruptcy. You also have to take a personal finance money management class after the bankruptcy has been filed, but before it's over with. So by the time your 341 meeting rolls around, if you haven't taken your second personal finance class, you need to get that done and get the certificate they give you for that second class to your bankruptcy attorney so they can file it with the court so you can receive a discharge in your bankruptcy. Because if you don't take that second class, your debts aren't discharged and you still owe them and you filed a bankruptcy, and that's never good. It'll cost you a lot more money later on to reopen the bankruptcy case. So get that test, that second class out of the way. Make sure you get your certificate to your bankruptcy attorney and that certificate gets filed. After your creditors meeting, there's some deadlines that the trustee and the creditors have to object to your exemptions. Either you've undervalued property, you've hidden property, or an exemption just doesn't apply. And then to object to the discharge of a specific debt. Either A, it's a non-dischargeable debt that you're trying to discharge, like a student loan, tax maybe, something like that. Or that it's typically an creditor objecting because of some type of fraud. You either ran up the debt right before filing, you lied when you applied for credit, something along those lines. After those deadlines have passed and you've taken your second personal finance class, the discharge is automatically entered and the bankruptcy is essentially over with. The whole process from the date of filing until the discharge takes about 4.5 months. Most of that time you're just waiting. All the work happens prior to filing, preparing everything, gathering all the documents, and getting it filed. And then after it's filed, it's pretty much just waiting and going through the process, waiting for the time frames to pass so you can receive your discharge. Like I said, it takes about 4.5 months from the date of filing until the discharge. You can't file Chapter 7 again for 8 years, and it typically stays on your credit report for up to 10 years. So that's a Chapter 7 in a very quick nutshell, and that will give you a general overview of a Chapter 7. Again, I would invite you to go to our website, shouldifileforbankruptcy.com, take our 15-question test.